Hello friends, welcome to my channel. It's the girl Mercy. If you're a returning subscriber, I appreciate you. If you're new to this channel, please hit the subscribe button. Share this video so I know that the discussion today will so benefit you. And I also admonish you to stay put and learn because I'll share a whole lot today. So today I'm going to talk about probate practice, making a will part 1, but it's a long discussion, so I might not be able to finish everything now. When in this part of the world, when we hear making a will, people feel like, oh wow, am I gonna die? You're not gonna die. Rather, making a will is more like securing the future of your estate while you're no more. It's a tool you use to express your intentions that will stand the test of time, even if you're no more alive. So most times Africans do not like making wills. I don't know why. They feel, what am I making will for? You say, they just come on to fine tune it to say, do I need it? I'm not dying now, and all of that. But over time, we have seen that death can come to the young, it can come to the old. So it's also important that you prepare, as you're preparing your life, as you're living your life, you prepare for life after death. So friends, this is Lawyers Infohub. If you're new to this channel and you're asking yourself, who is this lady talking? My name is Mercy, and I am the founder of Lawyers Infohub, and in this platform, I use it to reach out to lawyers, law students, young lawyers, old lawyers, people who are interested in law, and people who are also interested in whatever topic I'm sharing. Teach them, share life experience. Also invite people to talk about law and their own experience, all in a bid to make you a better lawyer, so that you have experience. You also understand some basic things about law practice. And most especially, I want, it's a platform where I inspire lawyers to become better lawyers in their field of endeavor. So back to our topic today, probate practice, making a will. Lest I forget, please kindly subscribe to this channel if you have not done so. Click the like button and share this video, because I know the information I share here is rich, is something that you would love to your friends to also listen to. Now, the question is, what is a will? Let's start. Sit back and listen. So now, a will is a testamentary and revocable document that is made, executed, and attested to according to law by a person named a testator, which is according to law. And this testator must have a sound disposing mind at the time of making the will. A sound disposing mind and memory. Yes, a will is testamentary because it takes effect after the death of the testator. Now, through a will, a testator, a person, can give further instructions with respect to the management of the estate, assets, after he or she must have passed on. Now, you know, when someone dies and the person doesn't, that maybe the person didn't make a will, sometimes it's difficult to ascertain what was the person's intention with respect to maybe what do we do with the cars, what do we do with the properties. Now the rules of intestate succession begin to come into play. This brother is dragging this one, this sister is dragging this one, this uncle is trying to drag, the children are left with nothing. So to curtail all this, which has been happening and which has always happened, it is better one has a will. Even as lawyers, most lawyers do not have a will. And as long as the draft will for clients, they do not have. They also encourage you as a lawyer to get a will. It's not too early to get a will. It's not too late to get a will. Anytime you decide, please have a will. It's a document that is for your own good and for your own safety. Now, what are the features of a will? The features of a will. Now, it has to be in a prescribed is in a prescribed form. A will must be in writing, and though it is not mandatory that it will be in a prescribed form. Yes, it is not mandatory that it will be in a prescribed form or in any special form for it to be valid. If it's not typed, it's not going to be valid. If it's not in this, it's no. Let it be in writing. Now you know that a will is the indication of the intention of a testator. So the will should be able to show um, those things, those wishes of a testator. Yes. Now, just like I earlier said, a will is testamentary because it takes effect after the death of the maker. Now, in comparing a will and a trust, you see that in a trust can be valid once it is created, even if the said law is alive. But a will cannot be effective when the testator is alive. Rather, it takes effect after the death of the testator. Yes. Now, when a trust is created in a will, it will be put on hold until the death of the testator. Yes. Where a trust is created in a will, to be put on hold until the death of the testator. Now, a will is ambulatory. Yes. It means it can be altered or revoked anytime during the life of the testator. Yes. The will is ambulatory because it can be altered, it can be revoked during the life of the testator. Testator can wake up tomorrow and say, I don't think that car or the land I gave to my wife is okay. Let me give her 3 more properties. Why I give my son this? So they can wake up tomorrow and say, okay, I've acquired more properties, I've acquired more things, I have more money now. I have a whole lot of things, a lot of establishments here and there. I have this, I have that. I think I should be able to give this to this person, to give this thing to this person too. So that way, the professor can change or alter what has already been written as a will, and affect those new things he wants. That's what makes the will ambulatory. Yes. So what are those terms you hear or you see in a will? So let me explain those terms, Tata. And as a lawyer, when you are drafting a will, those terms should also be reflected to show that you know what you're doing. Yes. As an excellent lawyer, as a smart lawyer, there are terms peculiar to some issues. So it's important that you use those terms so that whoever is reading it will understand, this was done by a lawyer. Now, who's a testator? I've been mentioning testator for some time now. The testator is the person who is making the will. Now, if it's a female, we call the person testatrix. If it's a male, testator. But most time, people just use the generic word testator for both male and female. Now, like I told you, testamentary that takes effect after death. Ambulatory is the word it takes that the testator can revoke or alter the will, anytime during his lifetime. Now we have executors. In a will, there's always executors. Executors has to be appointed. These are persons that have been authorized to administer a will. Persons that have been authorized to administer a will. They are called executors. Now, when you hear the word devise, devisa, is a term used when landed property is involved. The person might say, I devise the 3 plots of land I have in Lagos Island, Dolphin, to so person. I devise the estate I have in Maiduguri to my third son. I devise the 6-story building I have in Abuja to my last daughter. Now, when a landed property is used, the word devise is usually used. Then devicee is the beneficiary of the landed property. Yes. Now, when you hear the word bequest or legacy, that is gift of a movable property. Gift of movable property. That's a bequest. Can I use that word? The bequest so It must be a gift of a movable property to occur, something that is movable, you know. But sometimes, most of the time, all the gifts in the will are referred to as legacies. Now, who's a legatee? A legatee is a beneficiary of a movable property. Beneficiary of a movable property. Now, when you hear the word codicil, what is a codicil? Codicil is a miniature will, it's a mini will. It is used to amend or supplement a will. Now, the testator have made a will, and some subsequently feels I've acquired some other things I need to put in my will. Does okay, my second, do I need to come and alter and revoke the one I've earlier made? Lawyer, please, I want to add. So, as a lawyer, you can advise the client that you can do a codicil to supplement what is already in the will. So, a codicil is a small will, a mini will, a miniature will used to amend or supplement a will. It doesn't revoke the content of the original will, rather, it supplements it, it adds it. Rather than retrieve an already lodged will and start all over again, you can make a codicil and put it in, lodge it in to still go together with the original will. I hope you understand me at this point. That when you can use a codicil to amend or supplement a will, yes, you can use a codicil to amend and supplement a will. Now, what is a propound? Who is a propounder? A propounder is a person who is seeking for admission of a will. Who is a challenger? A challenger is a person who is contesting the validity of a will. We've seen so many times, so many instances, so many cases where people's protected will is challenged. The son is agreeing, the daughter is saying no, dad cannot do this, dad cannot give this person this and give me this. This family member, maybe it's a polygamous family, this set of the children are saying no, that will does not represent the death of our father. This person is saying that will does not represent it. My father should have given us this. So most of the time I've seen instances where wills are contested in court. Caveats are lodged in for the court to decide. Or someone is contesting, oh, my father didn't make a will. He never told me he made a will. So whatever will you're reading is nothing. Whatever will, people say a whole lot. Whatever will you're reading is not my father's will. My father can't do that. My father can't do that. So they end up, contesting that will. Now, when you read the word probate is the official or judicial confirmation of a will. Official or judicial confirmation of a will. Yes. Also, you hear letters of administration. Letters of administration are granted where no will was made by a testator. Now, the beneficiary, the family of the testator, the person who has died, will now apply for letters of administration where personal representatives will be appointed to manage the estate of the person who has died. Now, someone comes to you and say, "Lawyer, my lawyer, please, do you think I should make a will? Do you think it's important that I make a will?" Now, you must be able to understand the importance, the advantages of a will, so that it can be easy for you to expressly explain to this person, to this client, to this family member, to this intending client, the need for them to have a will. Yes. So to do that, you must understand what are the advantages of making a will. Now, as much as most people in this part of the world do not like making a will, but if you explain to them and they see reasons with you, why not? They will make a will. Even if you explain the reason and the advantages and the disadvantages, I think any reasonable person should be able to say, wow, this is important that I do it. Knowing the risks involved when it is not done. Now, one of the advantages of making a will is the exclusion of intestate rules of succession. Intestate rules of succession. Now, when someone dies without making a will, the person is subject to intestate rules of succession. This person will come and say, he lived in a Kogi state, and the Kogi law should be applicable. This person will go, no, he lived in Kogi all his life, but he's from Benue. Is the Benue law, native law and custom should regulate the sharing of his estate. This person comes and said, because I'm the his first brother, whatever he owns directly, devolves to me, because that's our custom. The person is no more there, so the estate is left to whoever can make a superior argument. So when you make a will, you exclude yourself from intestate rules of succession. So that should be one of the things to explain to your client, to anyone who asks you for the importance of making a will. Say one of the advantages of making a will is exclusion of intestate rules of succession to the estate of that person. So when the person is no more, everybody knows there's a will. This is what the person said, and we are willing to abide by the wishes of this person. Another importance of making a will is appointment of guardians and executors. Now, where a testator has young children and he said, maybe if I die, I don't know how these children will cope. I need to appoint this person, my friend, my auntie, to be a guardian to these children, pending when they become adults. Through the will, the testator can appoint people he or she feels that will help him or her train these children. They will be known as guardians, yes, to these children, and also appoint executors who will help manage and administer the will while taking care of the estate. Now, before the testator will use the opportunity to appoint trusted fellows, trusted friends, who knows that these ones, whether I'm there or not, my interest is in their heart, and they will see that my estate is not dissipated. So, in making a will, the testator has that privilege of appointing guardian over his children and appointing executors of his will. Yes. Another important advantage of making a will is the cost of probate. Yes. It is cheaper to secure probate than letters of administration. Tell your clients that, tell anyone who cares to know that securing probate is cheaper than letters of administration. Sometimes people are telling most people 2 years, 3 years, to get letters of administration for the estate of deceased person. And by the time they spend so much to get whatever is left in the bank or whatever property this person has, you see that what was recovered, just suppose it with the time lost, the time with they got it, the fees paid, the solicitor fee paid, the percentage we use the government, and all of that. You see that, does it really worth it? Is it worth the hurdle? Which, if you have made a will, you won't go this route. So explain to the person that it is cheaper to secure probate than letters of administration. Another important advantage of making a will is the security of the assets of the estate. Now, when executors are appointed by the testator, they will help prevent the dissipation of the properties, as they can even act before the grant of probate. Yes, the executors can act before the grant of estate. Have you not seen when most wealthy people die and where there is no will? And before the family will run around to fight each other to come to a table, come together to say, okay, let's do it this way. Most people have taken over the properties, and before they will recover all that they have lost, it will take a toll on them. Yes. So by making a will, the testator appoints executors who will help him to secure this estate. Another important factor to consider in making a will, that is another advantage of making a will, is expansion of the powers of the executors. The testator can expand the powers of the executor. Yes, to empower them to do anything that is reasonable, anything that is important, that is they can do to secure his estate, so far as it is the good of the estate that is within the ambit of the law. Yes, so the testator through his will can expand the powers of the executors. Another important advantage of making a will is that the testator is now at liberty to show generosity. He has an opportunity to show generosity. Normally, if a will is not made, someone who is not part of the family cannot come and say, I deserve to have that car, I deserve to have that house, I deserve this. No, 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 no. But where a will is made, the testator by himself can say, I give my gate man my so car. I gift my so land or a plot of land to my cook, which on a normal day the cook cannot get anything from the family of the testator. But through the will, the testator by himself can choose to show generosity and even affect the lives of people who are not even members of his family, donate to charity, give to people who are not even related to him, that way affecting their lives positively. So through a will, a testator has the opportunity to show generosity. That's important. Some of these testators couldn't do that when they were alive, but through that, okay, now I'm gone, now I'm going. Let this go to motherless baby home. Let this go to the orphanage. Let this go to the old people's home. Let this go to the prisons. That way, the testator has the opportunity to show generosity. So explain these things to your clients, and they'll be able to say, wow, I now understand why I should make a will. Another important advantage in making a will is that there is no break in the chain of representation. Now, where the executors are appointed, the chain of representation is usually not broken. You see, even when all the executors are dead, so the executors are dead, and maybe it's remaining one executor, and that executor makes a will and appoint the executor for his own will. That executor he has appointed for his own will still administer the will of the original testator. Yes, there's no break in the chain of representation. If all the testators died and remain one person, that person makes a will appointing his own executor. That executor he appointed will still administer the will of the initial testator. Yes, but where personal representatives have been appointed via the grant of letter of administration, and they die, fresh application will be made. Yes, for the appointment of this for of new personal representative through the letters of administration. Yes, it's quite different. In for letters of administration, if the representative die, fresh applications are made. But for the will, where the executors even die, even remaining one person who now makes a will and appoints an administrator, his executor, the executor will also administer that person's will and the initial testator's will. Another very important advantage of making a will is assurance of family cohesion. When a will is made and hopefully and everything, thankfully, the will is not contested by family members, and the family members abide by the the dictates of the wishes of the testator. There's unity. There's no fighting. Most people have been in court for the past 20 years over a will. And that way, the properties the estate are, every day it reduces in value. At the end of the day, by the time they are done in court, they might not get anything from the estate of the testator. So when the will is not contested, it helps to foster family unity, cohesion, it prevents bickering and fighting. Because most people that have contested wills, that have always been fighting over properties, they end up not even benefiting so much from that property. And where the will is not even made at all. Anybody with open eyes can collect things from the family without, by the time they attack and start fighting the person, years have passed And they might not get anything. One uncle from the village will come and take this. One auntie from somewhere will come. The brother will come. The sister will come. They say, "Ah, it's our brother. We made him who he is." By the time the family is left with nothing, nothing. So, but when a will is made, it it helps to foster family cohesion. Yes. Now, what are these laws applicable in probate practice, administration of estate in Nigeria? The statutes, legislations that we use, with respect to probate practice and administration of estate laws in Nigeria. Estate in Nigeria includes one, the Wills Act of 1837. The Will Act is the statute of general application and is applicable to states that have yet to pass their wills law. We have the Wills Act Amendment Act of 1852. This Wills Act Amendment Act, yes, of 1852 came into force specifically to amend Section 9 of the Wills Act of 1837, especially on the position of the signature of the testator and witnesses. So this Wills Amendment Act of 1852 came to amend Section 9 of the Wills Act of 1837. We have the wills law of various states. Most states have their own wills law. And then we have the administration of estate law of various states. Most states have their own administration of estate law. And as a lawyer, when you have a case or you have someone brings a brief for you with respect to this issue, so the first thing you have to do is look at the law of the states. Look at the various legislations and see what you're supposed to do, whether it's in line with the law and all of that. Also have the common law and doctrines of equity. The common law and doctrines of equity. The common law and doctrines of equity. These ones, they help. They're also part of the legislation. We have the customary laws on intestate succession. Yes, each state, each has their own customary law. Each tribe has their own customary law on intestate succession. If someone dies without making a will, how do we share his property? Who gets what? What does his wife get? What does his children get? Those division of 1/3 to third and all of that is important. It's in the under customary law of an intestate succession. So each culture, each tribe, each state has all that. So when you have a brief or there's an issue for you to resolve with respect to administration of estate, you have to look out for the law. Look at what is obtainable there, what is the custom saying, what is their law in the intestate succession saying. That way you make an informed decision. You can write a beautiful opinion on that issue. Now we have different types of wills. Yeah, we have different types of wills. First of all, we have the statutory will. Yes, statutory will. A statutory will is a will that is made in a special condition or special circumstances as to this is with persons without appropriate mental capacity. Yes, for people who have these mental issues, you know, I think that special consideration is given to them to make statutory wills. Yes, for them, people that have mental issues, don't have appropriate mental capacity to make a will. So the law comes up with this statutory will to cover them. We have the non-competitive will. Non-competitive will, NUNCUPATIVE. Non-competitive will. Non-competitive wills are wills that are made in anticipation of death by a testator. The testator who is already sick and is on his deathbed can make wishes on that deathbed to say, I want this to be done, I want this, knowing that anytime from now I might give up. So let me share my properties now. Let me do what I can do while I'm still breathing. So what do those wishes made by the testator on his sick bed is known as non-competitive will. They're usually made orally and they are valid under the native law and custom. Yes. But there are some considerations with respect to this type of will. It is valid if the testator had testamentary intention, and sound disposing mind. That the testator is sick and his deathbed, does he still have his memory intact? Can he remember does he know the effect of what he's saying as per his wishes? Can he decipher his testamentary intention? Does he have a sound disposing mind? These are the consideration. The testator that's in his sick bed, does he know all he has? Does he know his properties? These are considerations. The testator is on his deathbed, does he know the beneficiaries of those he's giving those properties to? Are the beneficiaries specified? Or I give my children that my car. I'll just come and make a general gift that will, at the end of the day, is better than was no wish was made. The beneficiaries must be specific and not just that. The instruction, those wishes must be made in the text of witnesses. There are people that will say, yes, so I was there when before he died, he said this, he said that. Because a lot of people have come under this competitive will to claim properties, and a lot of people are in court to say, when he was dying, he gave me this. When he was dying, he said I should have this. Are there witnesses? At the time he was making these wishes, does he have testamentary intention? Does he have a sound disposing mind? These are many more things you have to ask. Does he even know the beneficiaries, the specified beneficiaries? Does he know his properties, the nature of his estate and what he has? And most especially the properties the debtor is given his seed, are they disposable, or properties he has used as collateral, or properties that does not belong to him? Is it what he's giving out? No. So these are considerations. These are considerations. These are considerations. The properties given by the testator in sick must be disposable, not something he does not own, and not something that is already owned by another. So this issue of no cooperative has been subject of controversy, and a whole lot has happened, and a whole lot is still happening. We also have the written customary will. Yeah, even though it's customary where it's written, we have the customary will. We have the mutual will. This mutual will is the will made by two or more persons where they confer mutual benefits on each other. We have the holograph will. The holograph will. Holograph will. This is a will written and made by the testator himself, no witness, nobody, without any person. It's called a holograph will. So a holograph will, a will made by the testator himself without the presence of any witnesses, nothing. We have the prenuptial and the antenuptial will. This is the will made by the spouses before marriage, or will made after marriage. That's the prenuptial and antenuptial will. We have the privileged will. Now, privileged will are will made by persons giving special concession in terms of age or mode of execution or attestation. Maybe someone that's going to war, or military personnel, naval people, like, I might go and not come back. Let me make this will. Even though he has not reached the age of making a will, he can make a will. Yes. So maybe the young person and the need for him to just do something, can be considered under the privilege will. That's special concession, maybe as to age, mode of execution, attestation, these are the considerations that can be given to that person, but the will be a privileged will. We have the conditional will, is a will that is made subject to certain conditions. If this doesn't happen, this will not happen. Conditional will. Now, like I earlier stated, that when gifts that are given in the will are known as legacies. And now we have different types of legacies. Different types of legacies. Now we have specific legacy, a specific gift where it's why it's specific. There's no, I give my son my gold Rolex watch 2014 model. It's specific. You have the general legacy. I give my son one of my cars, which at the end of the day, any car can be given to the son. You have the demonstrative legacy. We have the pecuniary legacy, which is a monetary gift. We have the absolute gift. Once given is the person's own, nothing can just take it. It's absolute gift. We have the alternative gift. I give my son my BMW 2008 model. But peradventure he does not like it. He's at liberty to take the BMW 2010 model, alternative, alternate legacy. You know, we have the accumulated legacy, we have the contingent legacy. Contingent legacy is a gift that is given, but it's contingent upon the happening of an occurrence of something. We have the modal gift, that the modal legacy. We have the residual legacy. The residual legacy is like the bottom pot gift, the gift that is given after every other thing has been given. That's the last, the residual, gift. When I say I give my son, whatever that remains, or I can give my son a car after every other person must have, after all the gifts must have been given out, or not from the residuary from the bottom pot. I call it the bottom pot gift. That's the residuary legacy. We have the conditional legacy, a gift that is given that is based on certain conditions. We have the annuity. So these are many more are some of the types of legacies that we have. Now, where a gift has been given and um, for some reasons the beneficiary could not, access or have this gift. So something must have happened. Yes. So this is a concept of failed gift. Gift given in will can fail. It can be lost. The beneficiary may not be able to, enjoy the gift again. So what are those circumstances? What are those things that will make a gift in a will to fail? Yes. Now, under the doctrine of lapse, a gift may fail. Under the doctrine of lapse, now the beneficiary predeceased the testator. Yes. So where a beneficiary predeceased the testator, the gift given to him will fail. Yes, the gift given to him will fail because he has died before the testator. Now, another principle is under the principle of ademption. This comes to play where the gift was not in existence as at the time of death of the testator. Maybe the gift was in existence before, but at the time the testator died, the gift was no longer in existence. That way, the gift given to the person will fail or be lost. Also, under the principle of abatement. Now, under the principle of abatement, there's insufficiency of the estate. Maybe the testator has given a whole lot of people and doesn't know that the estate does not even have enough gift to cover these gifts they're given. Some people will get, some people will not get. So also under this principle of disclaimer. Under the principle of disclaimer here, the beneficiary by himself renounces the gift. I don't want the gift because this man, I don't want his gift, his house are not clean, I don't want, for whatever reason, a beneficiary may renounce the gift. That way the gift fails or is lost. Also, under the principle of attestation by beneficiary, a gift might fail or be lost. Now, also the principle of public policy, where it is the beneficiary is responsible for the death of the testator, his gift will fail. Yes, under the principle of public policy, where the beneficiary is responsible for the death of the testator, the gift will fail. Now, where a gift was given contrary to the doctrine of nemo dat quod non habet, a gift will fail because you can't give what you don't have. Where, for example, it is also gives the son a gift of a house, and not knowing that that house was used as a collateral, and the bank comes to take the house. The son cannot go to court and say, "My father gave me that house for this." The bank, no, because at the time the gift was given, the land, the property was not a part of the estate of the estate of it doesn't belong to him. Yes. So under the doctrine of nemo dat quod non habet, a gift will fail. A gift will fail. Or maybe the testator had already sold the gift and mistakenly gave it to the beneficiary. It will not fly. Now, a gift that is contingent upon a condition not fulfilled or satisfied will fail. That is under contingent legacies, where the testator says, I gift my son my mansion in Dubai when upon his completion of his university education and is of making and is obtaining a first class, where he makes a first class. The son can have that something complete education and he makes the first class. So where the condition is not satisfied, the gift will fail. Yeah. Where it's not fulfilled, where there's a condition, I give my wife the mansion in Barbados if after 4 years she doesn't remarry. The mansion in Barbados is contingent upon the wife not remarrying after 4 years of the death of the testator. So these are circumstances. These are circumstances that might arise, that will make a gift to fail. Now, a gift that was obtained by a beneficiary under fraud may fail. Yes, it may fail. It will fail. Not may, it will fail. But it is established that the beneficiary got that gift under fraud. It will fail. It will fail. So far, so good. I hope you're understanding and enjoying the lecture. I've discussed about what a will is all about, the features of a will, the essentials, talk about the terms in the will, we talked about advantages of making a will, talked about several types of legacies, we've talked about when a gift will fail. Yes, done so well. We've done so well in this video. Another thing I need to explain to you is how making a will. Now, for a client who comes to you and say, lawyer, I want to make a will, there's certain consideration you have to consider, you have to put in place, or bring to the front burner. One is you have to understand the type of will your testator wants to make. Does it have a sound disposing mind? Is he sick? These are considerations. Another thing is that you must take note of what the estate of the testator may be able to list out. I have this money in Swiss bank. I have my pension funds here. I have this money in euro. I have this one in this currency. All his assets, you must note it down. Every document, every asset, every property, everything he has, you must note it. Because if you don't note it, it will give room to sometimes you might overgive, those gifts. But if you have everything, if you say I give, sorry, you're already giving this out. So one of the things you have to do is to list out all the estate of the client. Then you name all the beneficiaries he wants to give the gift to. You name them. You get their full names. You name all his family members, his children, the wife. Then who are those that will be the executors of the will? Name, you list it out. If he needs appointed guardian, you lift it. You state it out. Then who are those that will be witnesses to the signing of the will? That's the execution of the will. You need to know them too. I know that at the point of signing the will, the witnesses must sign in the presence of each other. Now, as a lawyer who is preparing the document, you should not be named as a beneficiary in that will. If a lawyer who prepared the will is named a beneficiary in the will, that will is invalid. So as much as your client loves you and wants to give you something, he can take it in terms of your fees, or he can give you something different from that. Should not be named in the will. Yes, because once you are the maker of you prepare the will and you're named as a beneficiary, then there's a likelihood that you manipulated the testator, and the will be invalid. So as a lawyer, I have to be very careful. Now, some people have asked, how much do I charge in preparing a will? For me, charges are personal, but you should charge moderately. You should not charge like a market woman selling oranges or mangoes in the market. Everything also depends on your level. For a young lawyer, a lawyer might charge 300,000, 400,000, half a million for making a will. Yes, which also includes the lodgement, the preparing the will, also includes the lodgement fee and everything. Just everything that take care of the preparing of the will, sealing it, and lodging it. Some other person can charge 300,000, some other person can charge 200,000, but don't make a will for 20,000, don't make a will for 50,000. Even 100,000 is small. Yes, charge well, charge well. I've done a video on how to charge a professional. I think I'll put up the link on this video. This our profession is dignified, so don't bring it down. Don't bring down your standards. Raise it up. Charge well. You are a professional, and you're rendering professional services, and you have to be paid as a professional. Don't work as a professional and be paid as a cleaner. Don't work as a professional and receive the salary of a beggar. You are not a beggar. The will you're preparing for the testator is something that will outlive him. You must understand the importance of the will so that you also understand the importance of the charges you're asking him to pay. So charge very well. And I know that by the time you explain to your clients and the need for them to have a will, I don't know, you might get new briefs. You never can tell. You never can tell. Now, after the will has been made, the process of lodgement is another thing. Now, there's this concept I love seeing in Nollywood movies where when someone wants to read the will, the lawyer will come to the house, open the document and be reading. It's not done that way. Reading of will is done at the probate registry. So there are circumstances where the people from the probate can come, but normally that's an exceptional circumstance. Normally, the will is read at the probate registry. You see family members going for the reading of the will. If you've not seen it, go to the probate registry and check. Ask questions. That's where it's done. So these Nollywood people that are trying to misconstrue the whole process because they're not using professional lawyers in roles that involve law. That aside, how to lodge a will. Now, after you have prepared the will and the testator reads it and you say, okay, it's fine, I'm okay, they've executed the will. Now, as a lawyer, you don't have to be a flippant lawyer. Stop talking too much. Don't because he made it, the testator made the will, his family members are, hey, I didn't really do it. I just want to tell you, he made it, he has really it, so don't do that. That's a breach of trust imposed on you. That you are close to the family member should not make divulge information that are that is capable of causing damage to your client. So after you must have prepared the will, the testator has executed it, like it, okay, now it's time for you to lodge. You have to put it in an envelope, and that's called sealing. In sealing, in the normal way they seal is that they use the red wax to seal it round so that it cannot be easily opened. So the will is in an envelope that is sealed without red wax. If I'm getting it back, yes, you seal it properly. Then in your letterheaded paper, use and make an application. Make an application to the probate registrar, depending on who is in charge of the probate registrar, that's stating application for lodgement of will. I wish to lodge the will of my client, say the name of the person, so, and undertake to pay the necessary fees. Fees, I think 10,000 and above, depending on where you are practicing. After you have made the application, you need to go and make payments in the bank. Most of these things have been digitalized. But however, you make payment, you bring it back, the teller will confirm it, then they need to cite the testator. Yes, they need to see the testator. You have to feel, you have to feel. Some will cite, but some other people will not cite. I've been where they cited the testator. I've also been where they did not cite the testator and they collected it from me. But I'm sure that when you want to withdraw an already lodged will, they must see the testator. That one, they must see the testator and know why you're withdrawing the will. Yes. So when you come back from payment, they will now load it into the system and print out an acknowledgement copy for you. The acknowledgement copy will show that so will was lodged on so day. It might not be something you do in a day, it might be something you do in 2 days, 3 days, depending on the working capacity of the probate registry of where you practice. When submitting, take a come back later, you come back. You might take two copies, you might take one copy, but as a lawyer, you also need to have a copy. Sometimes you can also give a copy to the testator who have to keep it very well. But you as a lawyer who prepare the will, you should have a copy. Now, after you've lodged it and you've got the evidence of lodgement, you have to keep it safe because when you're coming for the reading of the will, they will need that document to show, or if you have a number, lodgement number, if you can have it, it also suffice. But you don't have it, you need to have to pay for search for them to search the records to know if actually you lost the will. And after the search and it is confirmed that the will was lost, then you can proceed with the reading of will process. Now, where the testator dies, and it is expected that the lawyer within 21 days to announce to the family that this person has a will. Everything depends on the period stated in the various states laws, as I earlier mentioned. So depending on where you are, you have to also check the law. But this within 21 days, the lawyer should notify the family, Mr. My client has a will, and whenever you are ready, you can go for the reading of the will. Now, as a lawyer, what you need to do is to apply again to the probate registry officer in charge for the reading of the will lodged on so, with lodgement number so. You make payment for reading of the will. Which everything is also digitalized. You can do that online. But most registries have not digitalized their process. That way, you have to visit the office physically to make this application. You make the application, they go through, they start looking for the will. A lot of people lodge will every day. People lodge will every day. So after you have made the payment, they will now give you the time to come because a lot of people come every day for the reading, so it's not what to do every day at the same time. So they will look at their own diary and give you the day that is convenient for them so that you can bring the family members for the will to be read. Now, on that day, when you come, the registry always have an open space where they do all this. Then it's the probate registrar or the reading officer will come and show to everyone this is the last will of Mr. So to show that it is sealed, has not been tampered with, and all of that. Then they will open it and read it. Then the family can apply to have a copy of the will so that they'll go back to put into effect all of those things. Some of the time, sometimes see that the testator might state how he wants to be buried. Yes, there's someone who will say, I want to be buried in my um, native land. I know I've already bought a vote at so cemetery. That is where I want to be buried. I want this. I want my burial to be peaceful. I don't want ceremony. And so we see some testators make provisions for how they will bury. You might say, okay, the money in so bank is specifically for my burial. Yes, you see a lot of things. Or sometimes you see people who go to cemeteries to buy burial spaces, burial ground spaces for themselves, so that when they die, they already know, okay, see, I have a space at so cemetery, please go and bury me there. So these are many more things that can be provided, that can be of the intention of the testator. Yes, it's a reflection, indication of expression of the testator's intention. So when that is done, the family can now go back and start sorting out and effecting. That is the executors who will be named. Will now say, okay, start working towards the administration of the will and all of that. Now, for lawyers, we have professional duty, not to allow for alteration of will. You have to be very careful. Just like I earlier said, that don't be flippant. That someone did a will and you help to draft it doesn't make you an answer. You've seen situations, you've seen in movies, you've seen in real life where family members connive with lawyers to, change things in a will. That is so bad. I condemn it with everything I have in me. So as a lawyer, you stand in a very high pedestal. Don't bring yourself down for Patrick's sum. Do not alter the intentions of a testator because you are privy to that information or you helped in preparing that document. That is so sad. Don't do that. Don't help to ignite fire in the family of another and think you'll be safe. Yes, you've seen things that sometimes lawyers are cajoled or threatened for, but that's even the sense of lodging. Once you lodge the will, I'm not with the will, it's not under your care again. So you have to be careful, but we still be careful. Don't allow yourself to be used by family members to alter the express intention of the testator, so that the testator's soul can rest in peace. Don't be a motivator of family disunity in the family of a testator. Now, please collect your fees in full. Collect your fees in full. You see, sometimes you see lawyers say, they are still owing me. Okay, because of that, I'll do this, I'll do that. Please collect your money in full. Before you render that service, you should have collected the money. Yes, before you render that service, you should have collected your money. You should have collected the money. And always advise your clients to do the right thing. Don't be someone who always tell that your second wife, I don't like her too. The last time, don't give her anything. No, don't manipulate your clients. Don't manipulate testators. Allow them from the depth of their heart to express their wishes, their intentions. Not because of one or two issues you have had with a family member or person. I said, don't worry, when your father is making a will, see what I'll do to you. I will tell him not to give you anything. That should not even happen. Allow the testator to be free. Allow the represent the intention of the testator in the way you're preparing, you're drafting. Don't come and say something and it's not what the testator is saying or the intention of the state because you feel you can tell him, no, that one is okay. Why are you giving him that car? Why are you giving him that mansion? What has it done for you? Is it not a troublesome child? Don't do that. Allow the testator to be free. Allow the testator to tell you as it is in his heart. Just like a doctor who will receive information from his patient before diagnosing and asking for diagnosis and all of that. Receive the information. Do the work you're supposed to do by preparing your will. You are not the owner of the properties. So the only thing you can do is to give advice, which you know before God and man is the best you can give. The best you can give. So, friends, it's been a wonderful session today. It's been a wonderful session today. Please like this video. Encourage your friends to click on the like button. Please subscribe to Lawyers Info Hub. I have great content in this channel. I've dealt on several topics. Check through the channel. Watch them, share to your friends. Probate practice is a very dicey practice in the sense that if you're not sure of it, if you do not really know it well, read, ask questions so you can read, so you don't miss inform or wrongly advise a client who will rely on you only to get wrong advice. What you don't know how to go about it, ask questions, let people know what your challenges are. They might put you to for people who have gone ahead of you. So in today's in today's video, we talked about probate practice, we talked about making a will, we talked about what a will is, we talked about the features of a will, terms of a will, advantages of making a will. We looked at the different types of legacies. We looked at the different types of will. We also looked at when will can fail or be lost. And we looked at it with in-depth analysis of them. And I also know that you will enjoy, and you've already enjoyed this video. Tell your friends about Lawyers Info Hub. If you have young students who are still within law, tell them about Lawyers Info Hub. If you have young colleagues at work, tell them about Lawyers Info Hub. Let me get your comments on this video. I would love to see your comments, really. I would love to see your comments, your criticism, if any. You can add something to this. Maybe there's something you know that I didn't add here. You can put it down on the comment section so that whoever will see this video will also see the comment and also learn. Yes, by so doing, you also contributed to knowledge in your own little way. Thank you for always tuning in to Lawyers Info Hub. Thank you for always liking this channel. Please support your girl Mercy. Subscribe if you have not subscribed. Share this video to your friend. Hit the notification bell so whenever I drop a new video, you will be the first to know. This is Lawyers Info Hub, as earlier said. You're welcome. We are here to give back to the society. We are here to contribute the little we can to the growth of the legal profession. We are here to see that a young lawyer can grow up to become an efficient lawyer. A lawyer who's not getting it right can also begin to get it right. This is a hub, information hub, where you get tips about law, about lawyers, about the life of a lawyer. Thank you very much. See you. Watch our videos. I know you keep loving them. Thank you very much.